Hi, I'm Mark Rygiel, a director with intellectual property law firms Sterne, Kessler, Goldstein Fox in Washington, D.C. The America Invents Act provided for a new administrative proceeding at the USPTO called a derivation proceeding, one of several new proceedings created under the AIA. The effective date of the derivation proceeding provision in the AIA is March 16, 2013. Derivation proceedings were created as a mechanism to determine whether the first person to file an application is actually a true inventor or whether that person derived the invention from another party. These proceedings are conducted by the Patent Trial and Appeal Board at the USPTO. The derivation proceeding requires that a petitioner who is also an applicant for patent file a petition to institute the proceeding against a third-party application or patent. The petition must provide sufficient information to identify the application or patent subject to the potential derivation proceeding and must demonstrate that the claimed invention in the subject application or patent was derived from an inventor named in the petitioner's application. The petition must also demonstrate that the inventor named in the petitioner's application did not authorize the filing of the earlier application claiming the derived invention. A derivation petition must satisfy important evidentiary requirements. In particular, the statute provides that a derivation showing is not sufficient unless it is supported by substantial evidence, including at least one affidavit addressing communication of the derived invention and lack of authorization for filing the earlier derived application. This showing of communication must be corroborated. So a proper derivation showing requires both an earlier conception by the party alleging derivation as well as corroborated communication of that invention to the alleged deriving party. There are also critical timing limitations when considering filing a petition to institute a derivation proceeding. The petition must be filed within 1 year of the date of the first publication of a claim to the allegedly derived invention. This publication may include a published application or an issued patent. A petition for derivation must also precisely set forth the relief requested by the petitioner. It's important to note that derivation proceedings contemplate providing relief whereby the inventorship of the earlier application filed by the alleged deriving party is corrected by adding the named inventor of the petitioner's later filed application and even possibly removing the alleged deriver from the first filed application altogether. Since each inventor has a joint ownership interest in an application or patent, the result of a derivation proceeding then can have meaningful consequences, such that one company actually attains ownership in a patent application another company filed. Given these potentially significant results, effective patent strategies are required by both the petitioner and the original first applicant, not only during the conduct of these proceedings, but also well before such a proceeding is even instituted. Because of the critical 1-year timeline for filing the derivation petition, it may be important to monitor published applications and issued patents in your industry or technology area. This may be an important strategy, particularly in situations where your company has a lot of outside relationships with manufacturers and vendors, for example. These are some of the areas where we often see issues with derivation and outright misappropriation of a true inventor's patentable subject matter. Although derivation proceedings differ from interferences in which the earliest inventor is determined, maintaining detailed records of the inventive process and any collaboration during that process remains critical. For example, lab notebooks that describe meetings with outside third parties, such as manufacturers, and emails that corroborate the communication of the invention to third parties can be necessary evidence to be included in a derivation petition. Of course, careful implementation of confidentiality and IP ownership agreements in conjunction with these relationships is also essential. Having a robust application filing strategy in place is sound advice for many reasons, but it can be particularly important in order to have your company prepared should a derivation issue arise. The standing requirement for derivation proceedings requires that the petitioner be an applicant for patent. The The board also requires that each party in the derivation is claiming subject matter that is actually patentable but for the potential derivation issue. Therefore, having a filing strategy implemented in which applications are timely filed proactively rather than in reaction to becoming aware of the derivation issue will help put your company on stronger footing should such a derivation proceeding actually go forward. Although we have not seen the same number of derivation proceedings instituted as we have with other AIA proceedings at the Patent Office, such as IPRs, they nevertheless are complex and useful tools. Companies should have sound strategies and good patent hygiene in place before a derivation issue ever arises to effectively protect their patent rights. Thank you.